On behalf of the Free Library of Philadelphia and the Social Science and History Department, let me welcome you to this evening's program. Without further ado, let me introduce you to our introductory host for this program, Nia Shelton.
Great. Hi, everyone. I hope everyone is doing well today. I am Anaya Shelton, and I am an AmeriCorps Vista, and I'm a data analyst and program coordinator for PMC. And I want to thank the Free Library of Philadelphia for hosting us. So first, I'm going to go a little bit into detail about who PMC is, and then I'm going to introduce our presenter. Would you like me to share my screen?
I have it, so let me share it. Okay. Can you see it?
Yes.
Okay, great.
So first, I want to say, please take a couple of minutes to scan this QR code. We do have a raffle for $25 for a Starbucks gift card, and we come out with the names quarterly. So please scan this. And if you don't scan it now, it will be at the end of the PowerPoint. So as we start to begin, if you do have any technical issues, please email us at staff@pmconline.org, or if you lose connection, you can call in on the Zoom. And for tonight's presenter discussing general legal topics, just remember they're not giving legal advice. And if you want specific legal advice, please consult with an attorney of your choice. And this program is going to be recorded. It's going to be at www.pmconline.org, and you can go on that website and click resources. I will put it in the chat box just so you remember, and at the end of the program. So a little bit of history about PMC. It was created over 30 years ago in order to fight for fair courts in Pennsylvania. And we are a nonprofit, nonpartisan organization, and we are dedicated to ensuring that Pennsylvanians come to our courts with confidence and will be heard by qualified, fair, and impartial judges. Also, we advocate for judicial reform and educate Pennsylvania about the courts and navigating them. And also we hold appellate court candidate forums. So a little bit about the work we do. We do have bail hearing reforms that we advocate for, and we do have judicial selection reform, and we do have workshops continuing on legal and judicial education with courses for judges and lawyers. And some of the programming that we have coming up is on this page, and we will be posting it on our website as well.
Okay.
So now I'm going to introduce our presenter, which is Deborah Gross. She is the president and CEO of PMC. She has over 35 years in private legal practice in federal and state courts over the country concentrating in commercial litigation. Also, she's a chancellor of the Philadelphia Bar Association in 2017. And she's the president of the Philadelphia Bar Foundation in 2013 and 14. And she has served on boards with Drexel Klein School of Law and Public Law Interest Center. And she has been a part of the Bar Foundation fundraising committee. And I just want to say thank you for presenting, and I'm going to pass it over.
Great. Thank you, Anaya. So I'm Debbie Gross. I'm the CEO of Pennsylvanians for Modern Courts. And I am a retooled civil litigator, is what I like to say. So first, I want everybody to put in the chat where they're from and if they voted yesterday, and why they voted and for what they voted. So I want to know if you voted, because voter turnout was not that great. So I'm curious as to how we can make it better. So we're going to talk a little bit about our Pennsylvania court system so you know where civil litigation fits in. Then we'll give a I'll say a civil litigation 101, because that's a very broad topic and it can encompass many different areas. And some examples of civil actions or small claims. So again, thank you for joining us, and I appreciate it. Okay, so great. I appreciate. So there were also judicial elections on the ballot, so you know. So a little bit about the structure of our court system quickly. It's triangular. That's whatever you see, this triangle all over the place. The highest court is our Supreme Court. It deals with issues. It is, like I like to say, the ultimate authority on issues of Pennsylvania law interpretation. The underneath our triangle, the next, we call them intermediate appellate courts, are our superior and commonwealth courts. Below that are our entry-level courts. We like to say we have a courts of common pleas and municipal courts or magisterial district courts. Are in Philadelphia, we have a municipal court. Outside of Philadelphia, in the other counties, we have magisterial district courts. So that's our triangle that forms the basis for the Pennsylvania court system. And just quickly about the Pennsylvania Supreme Court, as I said, it has the ultimate authority on matters that of Pennsylvania law. We just had on the ballot, will be one seat available on the Pennsylvania Supreme Court. So there were two candidates on the Republican primary and two candidates for in the Democratic primary, and one of each is a victor. So we'll be seeing the victor against the victor, I'll say, in the November general. So again, please, it's important to make sure you vote for these judges, because they truly make decisions that are going to impact your everyday life. We only have 6 Supreme Court justices right now, so we don't have anybody to break a tie. Examples of cases that that they have handled, or that we will see them handle. There will be, in all likelihood, a case brought for injunctive relief against the city of Philadelphia to stop one of its laws dealing with ghost guns, right? So we'll see what happens with the Supreme Court, but they deal with issues that impact our everyday life. It's really important. They dealt with, in 2022, they upheld the constitutionality of mail-in voting. So we just, I can't emphasize enough how much this Pennsylvania Supreme Court impacts your everyday life. When we start a civil action, if for some reason, the court that we're not happy in, or we're not pleased with the decision, I will say, the decision can be appealed, and the ultimate authority would be the Pennsylvania Supreme Court. We've heard a lot about, the Supreme Court in the press, but that really is the United States Supreme Court that we've heard about in the press, not so much our Pennsylvania Supreme Court. What we've heard about in the press about the U.S. Supreme Court has to do with this issue called ethics. Little issue, slightly important. But the U.S. Supreme Court doesn't have a code of conduct that it has to operate under. Our Pennsylvania judges, every single one of them, including our Pennsylvania Supreme Court, has a judicial code of conduct to which they are held accountable. Okay, our Supreme Court also, so doesn't just sit and hear cases. It has a lot of administrative and supervisory responsibilities. It has this office that oversees all the judges, make sure that they understand the law, right? They have to educate the judges. It has committees where it discusses rules, the rules of civil procedure, rules of criminal procedure. Should those rules be amended? Should they be changed? Should there be new rules? There is right now proposal dealing with, it's called informa pauperis, which means that an individual can't afford, for example, certain filing fees. How should the court address that? So these are important rules that the court promulgates. It also regulates the practice of law for attorneys and governing attorney admissions. So and governing judicial behavior. So our Supreme Court, in a nutshell, has a lot to do. The intermediate appellate courts, right, are the courts that issue typically decisions that are appealed to in the Supreme Court. Our Supreme Court can decide whether to take a case. That's known as discretionary authority, unless, of course, it has to do with a death penalty situation. But our appellate courts have the right and there's an automatic right of appeal. So, for example, our Superior Court I'm just making sure, sorry. Our Superior Court in Pennsylvania right now, so just going back to the judicial elections, there's going to be 2 open seats in the November general election. They too issue decisions that actually could be the ultimate authority of on law in Pennsylvania, because the Supreme Court may decide not to take an appeal from a decision on the Superior Court. So, there are examples here of cases that the Superior Court has taken appeals on, but they also take appeals of cases, an automobile accident case, and stacking, on availability of insurance policies, or a nursing home case where, is this agreement unconscionable? Can it be enforced, in other words? So the Superior Court it's one of the busiest courts in our country, writes a lot of decisions. So, as I like to say, these judges better enjoy writing. And that's one of our intermediate appellate courts. The other intermediate appellate court is this court called the Commonwealth Court. It's a relatively newer court, I would like to say, and it's unique in the United States. It was created because our Superior Court was so busy. It handles mainly cases brought by the Commonwealth, by counties, townships, against counties and townships. It handles appeals of administrative agency decisions. It also handles cases against SEPTA. But I think one of the most important cases that it recently decided was a case concerning the constitutionality of funding of education in Pennsylvania. So our Commonwealth Court had months of trial, actually issued an 800-page decision, which the bottom line is they said that the way Pennsylvania funds its education is unconstitutional. And again, the election, the primary election that we just had, there were a few candidates running for each from the Democrats and the Republicans. There will be one candidate running from each party in the general, because there is one seat available. And again, you could start a case in the Commonwealth Court, but you could also appeal a case to the Commonwealth Court. But we like to talk about most civil litigation really starts in entry-level courts. And our entry-level courts are either our courts of common pleas or our municipal court or magisterial district courts. And the difference between the two is the amount of the damages or harm, involved in the matter, right? So if it's less than $12,000, typically and most likely, the case will be filed in the municipal or magisterial district court. It will be known as a small claim. And many individuals who file in municipal or magisterial district court do it by themselves. You don't necessarily need a lawyer. I like to say a lawyer always helps. Sometimes if you're sued, as we're going to discuss this later, in municipal or magisterial district court, and you receive notice of the lawsuit, you can't ignore it. You need to make sure that you respond. Okay, if you have a matter that's over $12,000, it should be filed in a court of common pleas. Additionally, if there's a decision from the municipal court or magisterial district court that you're not happy with, right? Because municipal and magisterial district courts there's no jury trials. The judge makes the decision on the matter. it could be appealed to a court of common pleas. The Court of Common Pleas does hold civil and criminal jury trials. There's a question about magisterial courts. Are they required to post filing fees in their local rules? Usually the filing fees are listed on a website. Are they required? I don't have an answer for that, but I can look into it. Okay. But they should be listed on the court's website. So, that's the first, this is a quick overview of our courts. And now I'm going to talk about what does civil litigation mean, right? So what does civil litigation mean? It's a matter that's between two private parties. There's not a government authority, not a prosecutor, not a district attorney that's bringing a case for a violation of a criminal law, but this is a civil suit, meaning it's two private parties who have a dispute, I will say. There's a difference in the proof that's required in a civil suit versus a criminal case. In a civil suit, plaintiffs must have a preponderance of the evidence. This must prove their case by preponderance of the evidence. I'd like to say that's about 50.5%. And again, there's no right to an attorney, but for certain limited matters in a civil case. And there is and most, other than in municipal court and magisterial district court, you would have a jury. So I'm going to go back a step. But what do you need to do to determine whether you have a civil case, right? Most important, make sure you gather all your information. Make sure you have it, because when you go into court to file a statement of claim or a complaint, or it's the first document, I will say, that starts the case, you need to have your information. If it's a contract or an agreement, maybe it's an informal agreement, it's some writing that, and even an email, right? That's a document. Make sure you have that document. Also, make sure you have a general understanding of the law and not simply from what you see on TV, because laws are different based on state, based on municipality, based on township. So there are minor, but there are variations in the law. You also need to know that while you think you have a great case or a strong case, you will never be guaranteed to understand how a case will turn out. I have tried. I like to say I used to have these massive class actions where we had some amazing emails or documents that looked like they could turn the case, but then we went to trial, and for example, something happened in the news about maybe the trial or about something about the economy, and we knew that we would not have the jurors on our side, so we decided it was time to try to mediate and settle it. And why I say that is because most cases can and do get resolved out of court, and that's either known through mediation, through arbitration, through some type of intermediary. And I like to say that if both sides are unhappy with how the mediation or mediator or arbitrator makes a decision, typically that's usually a good decision, because when one side's happy and the other side's not, that's not an even balance of power, and that's where there's usually an appeal from an order. But if both sides are unhappy or both sides are happy, it means that the mediator or arbitrator or middle, whoever we used, has resolved the case in somewhat of a fair manner. So, what are the different types of civil actions, right? We have heard the term contract actions. Is there a written agreement? Is there an unwritten agreement? Has it been broken or breached, right? So these are various examples of types of agreements, right? You take out a credit card. You will have, that means that for you to take out that credit card, you have actually signed a document that is an agreement under which which you should be operating. And if you don't, typically the credit cards companies, it's a pretty basic agreement. It has to do with when you have to pay in a timely manner. And if you don't pay in a timely manner, there will be late fees and administrative fees and interest fees charged. There could be an agreement for insurance that you have with your insurance company, with respect to an automobile, with respect to your house. So there's many different types of contracts that people enter into every day. Landlord tenant, there's should be, we have a whole separate program on that, but there should be a written agreement that would I'll say govern the relationship between the landlord and the tenant, between the seller and the buyer. So these contracts are really important for you to make sure that you read them before you sign them. And really, they should be in writing. It is much more difficult for a case to be proven when it's one person's word versus another person's word. It's then really the jury's deciding or the judge is deciding based on somebody's whether you have a good day in court, honestly, right? How you communicate your position. So I always say, if you can have a written agreement, you should. The next type of civil matter would be a negligence action. And a negligence action really means, is there a duty that has been breached, right? Is there some kind of, did the person, is there a hazard such as a the limb that has created a bump up in the sidewalk that somebody has fallen on? Should the owner of the property where the tree limb and the sidewalk bump it resides on or is located, does that person have knowledge of that hazard? And should they have done something so that you wouldn't have tripped on it? So these are, is there in an automobile accident? It's a negligence matter. Somebody has blown through a red light or a stop sign and hit somebody else. There are various ways to litigate. Typically, I'm just going to give a heads up. We talked about how you need to get a lawyer. And negligence actions, typically lawyers take matters on a contingent basis. That means that they will waive. I'll say they will not have to be paid unless there is some kind of recovery. So therefore, make sure you read the agreement, and it says that. Sometimes it also should say that if the lawyer doesn't win the case or doesn't resolve the matter in a way in which there's some money coming back to you, then the lawyers could would also waive any kind of costs and expenses. But again, if you're going to enter into an agreement with an attorney, right, make sure you read the agreement and understand the terms. So, again, contract actions, negligence actions are civil actions that can be brought in Court of Common Pleas or municipal court or magisterial district court. And so, these are the basics, right? You need to know when you go into court, because you're going to file what's known as a complaint or a statement of claim. Again, it's the first document, I'll say, which initiates the action. Who is involved? Who are the parties? I mean, you'll need to, when you go into court, you'll need to know the name of the party. You'll need to know where the contract, where the dispute arises, right? Some contracts actually say where the complaint has to be filed, what law governs it. So that's, again, you need to read the fine print, because usually it's in fine print. Where's the property located, right? Where did the auto accident occur? Where did the harm occur? You also should know about your damages, right? How much are you seeking to recover? If the car has been damaged, if maybe a tree hit the car, make sure, or you've gotten into an unfortunate auto accident, like, make sure you have proof of harm, of the damages. All these will support your case, and help you, with the litigation. So again, here are some examples of documents, which I've sort of already said, but documents for a contract case, again, if you have the agreement, you should attach it to the complaint. If you have been sued, right, and you have a different agreement than is attached to the complaint, or make sure you attach that to your answer. If there are photographs, if there are bills, if there are emails, if there are affidavits from witnesses, all these are examples of documentation, which are really important in helping you litigate or defend, litigate your case or defend your case. So, why do you go to civil claims court? We sort of explained this, but it has to do with you want to recover, right, for your harm. The filing fees in different courts, as somebody noted, will be different based on where the case is filed. A municipal court in Philadelphia has certain filing fees. A magisterial district court in Montgomery County has different filing fees. So again, you can check the Montgomery County Court website, for example, to see the filing fees for a magisterial district court or a court of common pleas. So for this is an example, and this is very wordy, so I will try to go through this slowly, but this is the actual court process for filing a small claim in municipal court in Philadelphia. It's important to understand that, you have to know where to go, right? So go online again, find out where the court is located. You'll need to go to the filing office. There are individuals in the clerk's office who can help you with the forms. They cannot give any legal advice. The forms are also available online, and we'll get to that in a little bit. So maybe print out the form ahead of time, fill it out ahead of time, or you at least read it and know what's required. And if you have any questions, then the clerk's office can assist you with those questions. Again, they cannot give any kind of legal advice. After the complaint is filed, right, the complaint is going to be filed with documents. There's this next step, which is called service. The complaint must be served, and there must be proof of service filed with the court to show that the opposite side, the defendant, has received notice of the complaint, and then the court will set a hearing date. And I say this all the time, but you cannot, if you are in the receiving end of a complaint or a statement of claim, and you are notified by summons of a hearing, you can't just not show up. It doesn't mean you'll automatically lose your case, but I would say about 85% of the time, you have a good chance that there will be a default judgment entered against you. And then you'd have to file, a motion to lift that default judgment. So it is, if for some reason that hearing date is not good for you, for your schedule, don't ignore it, but call the court and ask for the hearing date to be continued. or, and give a date that's more of that works for you. Also, it's important for that at that hearing date in small claims court, when you get that hearing date, that's actually not just a hearing, but it's a trial date. So when you go, it's a date that the judge expects you to come to court to defend or to prosecute, but to have all your witnesses. So if your witnesses are not available on that day, make sure you let the court know and ask to reschedule. So these are really important. I mean, courts will give continuances. They're not the sticklers about not giving continuances, but you need to have an explanation, a good explanation why you need a continuance. So, again, we have the first step is the filing of a complaint, and where it gets filed is most important. And also, there is such a thing as called a statute of limitations. So it varies based on the type of claim you're filing. But if you wait, 5 years, it may be too late. So make sure, you don't sit on the matter, and make sure you are timely in claiming and in filing your claim. Okay, so this is an example of a complaint cover sheet for the Court of Common Pleas, and I have a website that's listed, and this is a form that needs to be filled out. It already looks like overwhelming, and again, the clerk's office can help you complete this form. As an aside, we will send out this PowerPoint to all those who are attending so that you can have access to the website, have access to the forms, and it will, assist you in hopefully your path down to defending or prosecuting litigation. Again, this is another form. This is the form of a complaint. This is it's pretty easy, right? This is a form that's filled out in municipal court and magisterial district courts. You actually don't have to write that much detail in it, but you do need to explain that you have this contract, or it involves this location or this car accident, and where and give some basic information, when the contract was entered into, how it was breached or how it was broken, and why and what your damages are. I mean, make sure that at least that kind of information is included in this statement of claim, it's known as, or complaint. Again, I do say if you are really confused, I highly recommend that you hire an attorney. Many of the bar associations have lawyer referral services that you can reach out to for an attorney. If you are at a certain income level, you may qualify for a pro bono attorney, which means that there's an attorney who will help you without any cost. There's also now this terminology of low bono, so it's a lower charge from an attorney based on income. So and then if you decide to represent yourself, but you're at a certain income level, there's this legal Latin term called informa pauperis, and you need to ask the clerk's office for this form. It is not always plastered in every clerk's office, but make sure you say, I can't afford this filing fee. Is there a form that I could fill out that would waive this filing fee? So, these are all things that you need to know and ask for when you go into the clerk's office. This is similarly, the Philadelphia Municipal Court statement of claim. You can fill it out yourself. You need to sign it. You'll also need to complete an affidavit of non-military form for the defendant. So, just know this. As I mentioned before, so the first step is to fill out that statement of claim, fill out that complaint with as much information as you have, attach any kind of agreement. Even if you're in an auto accident and maybe there was a police report, attach the police report. There are documents, attach an email, whatever it is, if it'll help the judge make a decision as to who is at fault, or, make sure you attach it. So then, as I said, after the complaint is filed, it needs to be served. And this is just sort of explains, how you go, what service is. There is a process you'll have to pay for to have the service made. And again, if you can't afford the service, you need to fill out the form about informa pauperis, and hopefully it can get waived. So on the other hand, that's what you do if you are bringing a lawsuit, to recover or protect your rights, okay? However, if you have been sued and you are a defendant, right, what do you do? So you've gotten this summons or this notice of the lawsuit. You've gotten a hearing date. So you need to, again, make sure you attend the hearing. Or if you can't attend, make sure you write a letter explaining why you can't attend. If you do attend the hearing, bring your evidence, right? It's really important. Credit card companies often sell their debt to these entities that are just an amalgamator, right? They collect the debt and they come into court and they file a complaint against somebody who hasn't paid their credit card debt. Well, you can say, if you're on the receiving end of that lawsuit, where's the agreement? Where's the proof that this is me, that I've signed this agreement? Also, they can't just say that you owe money. Where's the proof of the outstanding amount, and that you've actually used that credit card? So don't just assume that the lawsuit is against you is correct, right? And that you're going to avoid it. But look at the lawsuit, look at the language, make sure that there's documentation to support that lawsuit or that claim against you. And if not, challenge it. So there are, different ways to challenge it, I will say. So one, we mentioned in the beginning, you could try to negotiate a resolution. There are various organizations, nonprofit organizations, that will help with mediation. Some do it for no charge, some do it for a low charge, I will say. But oftentimes, as I like to say, if you can negotiate a settlement, that would be best. Also, the other thing that's important is that if you don't negotiate a settlement and you go to court and there is the trial and there is a decision, you now have a record, and it is in and it's open to the public. So anybody can search court filings and decisions and see if there's a decision against you, and, say, okay, so, or see that you're a litigant. So, and that you're maybe a frequent litigant. So if something can be resolved out of court, I always say, give it a try and hopefully see if you can make it work. Other options for response to a lawsuit, right? You can hire an attorney. You can call your insurance company. So if you are in the receiving end of a lawsuit, maybe based on insurance litigation, based on some kind of contractor who's come into your house and gotten hurt, and you have insurance coverage, call your insurance company. That's why you are paying for that insurance. It's so that you can be protected. Oftentimes, they hire the attorney. Just make sure you talk to that attorney and tell that attorney your story. If you can't afford an attorney, you haven't the insurance, you can always represent yourself. And again, if you do that and you don't understand what's going on, make sure you just ask the court questions, but in a respectful manner. Don't go in screaming, but judges are elected by the people. They report to the people, and they will help you understand the situation. You have to, one of the options, again, to respond to a lawsuit is maybe what's known as a counterclaim, that you're filing, if you're a defendant, you're filing a claim against the individual who's brought the lawsuit. It's called a counterclaim, or you could bring your own lawsuit. I would recommend filing a counterclaim in that, it's sort of, this way it's all before one judge in one matter. When you file your own complaint, there's a chance it could be in front of a different judge, and have a different schedule. So unless the cases would get consolidated, but that's, but again, these are various ways to respond to a lawsuit. So now we have this hearing date, this trial, and it is a trial. It is where the matter will be heard in municipal court and magisterial district court. Remember, it's heard by judges. The judges make decisions. So it's important that you be prepared, that you be prompt. I would tell you, I say be on time here, but I would actually tell you to get there early so you can sit in the courtroom, watch what has happened before your case, because usually there's more than one case on the judge's calendar. And so you can sort of see what's going on so that you're not going in completely unprepared, and you'll get to know the judge. You'll see how the judge decides matters, how the judge asks questions. It's, observation is really important. And again, be respectful. Don't be combative with the judge. You can ask a question of the court and say, I didn't understand, but the judge will be in municipal court and magisterial district court, the ultimate arbiter of the law. In a court of common pleas, you will have a jury trial. So you're going to make sure, and the jury is the jury of your peers, right? So make sure you're respectful of them. Also, make sure you're clear. Don't, make sure you tell the story of your case in a logical and chronological manner. Make sure you have witnesses if there are witnesses. Make sure that you have documents and they're not on your phone. Okay. If you have pictures of the damage, of the harm, you're not going to show pictures to a judge or the jury from your phone. So make sure you've printed them up. You're going to have to give them to the other side so that the other side has notice of what you're going to do to prove your case. But, bring the pictures. And also answer the judge's questions. I mean, even lawyers, how do I say this properly? Even lawyers could hurt their case by not answering a judge's question. So I always say, after the judge asks a question, take a pause. Lawsuits are very emotional, and you can get all worked up, but take a pause, take a deep breath, listen to the judge's question and answer it. How about a video like a traffic ticket dispute? You can absolutely and should absolutely bring a video to court. I say that, but you should make sure that what you videoed is legal. Okay. So for example, you can't record anything in the courtroom. It's against Pennsylvania law to record anything that goes on in the court. It's against Pennsylvania law to record a telephone conversation. Okay, it's a violation of our wiretap statutes. So make sure that if you're going to bring a video, you've taken that video in a legal manner, because you don't want to put yourself into any criminal situation. So that's a video of the traffic accident is fine. Remember, you can probably obtain the camera, right? Many of our cameras, many of our stoplights have cameras. Many people have cameras outside of houses. There's even now little cameras just watching us all the time. So, yes, those, as long as you obtain them in a legal fashion, you can bring them into court. So now we've presented our case. Most cases shouldn't take more than a day to present. When they get more complicated, yes, they take more than a day. And the judge or the jury, right, can decide the case. So in municipal court, magisterial district court, the judge makes a decision. The judge typically does not make a decision from the bench. The judge has in landlord-tenant court 3 days to render an opinion. It is usually a written opinion. It's important, that you get that order, like the judge signs an order, even if the judge renders a decision from the bench, right, says it right out loud there should be a written order, and you need a written order because that's what you appeal. So there is an automatic right to appeal, again, from municipal magisterial district court. It would be appealed to the Court of Common Pleas. If there is a jury decision or in the Court of Common Pleas, it can be appealed to the Superior Court. I also should mention that you could waive your right to a jury in the Court of Common Pleas. That's not something you should do without seeking counsel. The jury system has been in existence, for a very long time. And I would, that means that you're going to have a judge make the decision. It's known also as a bench trial. And I would think carefully about the decision to waive your right to a jury. So now the judge has issued this decision, and if you're not happy with it, right, you can decide to appeal. The appeal process is expensive. It is time consuming. The filing fees can be waived if you are at or below a certain income level. Again, you need to ask about the informa pauperis papers. But if you're happy with the decision, and the other side decides not to comply with it, right? You're going to need to figure out how you enforce it, right? How you collect it. And it's not something that you should be doing. So you're going to file a motion to enforce, or a motion to collect. So, I've already gone through that. Sorry about that. So, a motion to enforce the judgment or a precipice for a writ of execution. So again, you're not going to go knocking on that person's door and say, you owe me $30,000 or $3,000 or $12,000. Okay. But you'll end up having to file a motion to enforce a judgment or a precipice for a writ of execution. You can reach some kind of agreement with the party that you're opposing. If you're a plaintiff, you can reach an agreement with the defendant. If you're a defendant, you can reach an agreement with a plaintiff about how it's paid. Sometimes the court will help you reach an agreement as to how this is paid. It could be paid over time, in monthly, divided over 12 months, or it could be paid in one lump sum. So, nevertheless, if you can't reach an agreement, you must be proactive in your efforts to enforce the judgment, because otherwise the court will think that you're really if you're not active in it, then you waive your right to collect it. So again, make sure that you can give there's a time period for which you can hope that the defendant will pay, but if not, then you need to move to enforce the judgment or precipice for writ of execution. So I have done a lot of talking. I'm just looking to see if there are any more questions in the chat. I don't see any. We have this list of resources. Again, there's a lot of information. In the Philadelphia Municipal Court, there's forms, there's information, there's even some quick videos about how the process works. Also on the Pennsylvania Court website, it's pacourts.us. There are forms, there are videos. You can also always call the Philadelphia Bar Association, as I said, the lawyer referral service. And different county bar associations have different lawyer referral services. In Philadelphia Court of Common Pleas, there is an Elder Justice Center and Civil Justice Center, which is in City Hall, which will answer questions. So there's many different resources that you can avail yourself of, even if you're a plaintiff or a defendant, you are not alone. And the court is happy to help, as well as various nonprofits. So are there any questions? And if not, again, I have, we have our QR code. So please complete the survey. We need it to show that we've helped people. I see something in chat, maybe.
So we have one raised hand.
Okay.
So you can unmute, so we can hear what your question is.
Hi, I was just wondering, I have I live in an apartment building. The building next door, there's a lot of noise coming from there. And I got a police report for it, and I called the city about it. They say that they're sending them a letter or whatever. Is there anything else I could do? And I know it's off the topic. I know it,
No, but I know what you're saying. Well, if it's, there are noise ordinances, right? So if somebody's violating a noise ordinance, you could, and it's a repeated situation, you could refer it to the district attorney's office. I can't tell you a district attorney's office would take the matter.
Right.
But if there's a concern with safety, right, or if there's then the district attorney's office might be more interested.
Okay, well, I don't think there's safety, but it's
just the noise.
It's loud, and it's all day and all night.
So there are clearly laws about noise levels.
Okay.
You could bring a private matter against them. I just, if they're tenants, and it's sort of it may be hard to enforce it, unfortunately.
Okay, well, thank you.
But I guess you could talk to, if they're tenants, you could reach out to the landlord, because the landlord may not know about it, right? And then they also could be violating terms of their lease agreement with the landlord.
What I'm not sure whether they're condos or that's the thing. And my apartment is a cooperative apartment. So it's
so then so is it part of the co-op building, or no, it's a separate building next?
It's a separate building. It's the building next door, and they own it. They're out of New York. The owners are in New York. They're not in Philadelphia.
So the owners are renting they're
renting apartments or condos, whatever, next door to us.
Right. So the condo itself, I hate this is like getting really complicated, so I apologize. The condo itself could have some condo documents that talk about noise levels, and if the so you could send a letter to the condo board.
Okay.
Right. Every condo has a board that runs it, saying that they're loud, they're in violation of, like, you could Google and find out whatever laws there are there. I know that there are noise ordinances,
right. Okay. Yes, I do know that on the Philadelphia.gov, it does talk about a noise ordinance. So there is laws about that. Well, thank you. Thanks a lot.
Okay. Hopefully that's helpful.
Yeah.
Okay. Anyone else for any questions? Well, thank you for your time tonight. It's beautiful outside, and I know you have options. So thank you for joining us, and have a great night.